Alright, so today I want to look at the Bill of Rights that the British government have changed. And here is the Bill of Rights documents that they have changed on the 22nd of June. So we're going to have a quick read of the details, and then we're going to go on to the 11 main points that they have decided to change. Right, so the government is delivering on our manifesto commitment to overhaul the Human Rights Act and replace it with a Bill of Rights, which has been introduced to Parliament today, the 22nd of June 2020. This country has a long and proud tradition of freedom which our bill enhances, for example in respect of freedom of speech and recognition of the role of jury trial. Equal over the years, mission creep has resulted in human rights law being used for more and more purposes, with elastic interpretations that go way beyond anything that the architects of the convention had in mind. Following careful consideration of the responses to the government's conciliation of the Bill of Rights, these reforms reinforce our tradition of liberty whilst curtailing the abuse of human rights, restoring some common sense to our justice system, and ensuring that our human rights framework meets the needs of the society it serves. As we make these reforms, we are clear that we are committed to remaining party to the European Convention of Human Rights, ECHR, the bill. Number 1. Right, strengthen the right to freedom of speech. We are attaching greater weight to freedom of speech, defined as the exchange of ideas, opinions, information and facts as a matter of utmost public interest, and widening the responsibility for attaching this greater weight to all public authorities. Number 2. Recognises the right to jury trial. The bill recognises the right to trial by jury under the subject to the framework set by Parliament and the Scottish and Northern Ireland legislatures. Number 3. Limits courts' powers for certain rights. Human rights, especially Article 8, right to family life, have been used to frustrate the deportation of criminals. The bill will apply when a court considers deportation laws, especially those that may seek in the future to make it more difficult for foreign criminals to use Article 8 to appeal their deportation. It will set out that the legislation must be found compatible with those rights if it meets a new test which the Bill of Rights sets out. This will restore credibility to the system and ensure we can protect the public by deporting those who pose a serious threat. Number 4. Reduces burdens on public authorities. We are limiting the imposition of positive obligations on our public services without proper democratic oversight. We are making clear that when public authorities are giving clear effect to primary legislation, they are not acting unlawfully. We are doing this by restricting UK courts' power to interrupt legislation. This will deliver greater certainty for public services to do the jobs entrusted to them, without the constant threat of having to defend against expensive human rights. 5. Ensures that public protection is given due regard in interpretation of the rights. The bill contains a provision that obliges all those who interpret convention rights to consider the need to reduce the risk to the public from convicted criminals serving a custodial sentence. This supports the government's proposed reforms to the parole board and strengthens the government's hand in fighting Article 8 claims from terrorists opposing their placement in separation centres. Number 6. Limits the bill's territorial jurisdiction. Domestic and Strasbourg case laws has extended beyond the intent of the convention's drafters. The bill excludes extraditional jurisdiction for military operations abroad. Number 7. Implements a permission stage to ensure trivial cases do not undermine public confidence in human rights. The introduction of a permission stage will ensure that courts focus on serious human rights claims and places responsibility on the claimant to demonstrate that they have suffered a significant disadvantage before a human rights claim can be heard in court. Number 8. Recognizes the responsibilities exist alongside rights. We are recognizing that responsibilities exist alongside rights and ensuring that appropriateness of paying damages to those who have infringed the rights of others is considered. Number 9. Strengthens domestic institutions and the primacy of UK law. The bill empowers UK courts to apply human rights in the UK context, affirming the Supreme Court's independence from the Strasbourg Court. The bill makes explicit that the UK Supreme Court is the ultimate judicial arbiter. Number 10. Increases domestic oversight. The bill makes sure that the balance between our domestic institution is right by repealing Section 3 of the Human Rights Act 1998 to ensure that the UK courts can no longer alter legislation contrary to its arbitrary meaning and the overall purpose of the law. Number 11. Enhances Parliament's role in responding to adverse Strasbourg rulings. The bill enhances the role of Parliament in responding to adverse Strasbourg judgment against the UK. The bill also affirms Parliament's supremacy in the making of laws. Alright, so the first one strengthens the right of freedom of speech. We are attaching greater weight to the freedom of speech defined as the exchange of ideas, opinions, information and facts as a matter of utmost public interest, and widening the responsibility of attaching the greater weight to all public authorities. Which I think, I personally think freedom of speech is not protected enough in the UK. It is somewhat, because under the Article 10 of the Human Rights Act of 1998, everyone has the right to freedom of expression in the UK. The law goes on to say that this freedom may be subject to formalities, conditions and restrictions or penalties as are prescribed by the law and are necessary in a democratic society. I reckon, yeah, freedom of, the first one is fine. I don't see an issue with at all. Alright, so on the Bill of Rights, so number 2, I'm not quite sure how the jury trials and the framework works, so I don't want to really talk about it because I don't know much about it to comment. But number 3, though, is I find quite concerning. Limit courts' powers for certain rights, human rights, especially Article 8, the right to family life, have been used to frustrate the deportation of criminals. The bill will apply when a court considers deportation laws, especially those that may seek in the future to make it more difficult for foreign criminals to use Article 8 to appeal their deportation. It will set out that the legislation must be found compatible with those rights. If it meets a new test which the Bill of Rights sets out, this will restore credibility to the system and ensure that we can protect the public by deporting those who pose a serious threat. Now, obviously the main keyword is, key phrases is Article 8 and right to family life. So, on the Equality and Human Rights Commission webpage, on Article 8, alright, if you just have to scroll down to what is meant by family life. So this is what they mean. You have the right to enjoy family relationships without interference from the government. This includes the right to live with your family, and where this is not possible, the right to regular contact. Family life can include the relationship between an unmarried couple, an adopted child and the adoptive parent, and a foster parent and a foster child. Now, I don't see how any of this, right, the right to family life, somehow interferes with deportation of foreign criminals. Because bearing in mind, this article, Article 8, family life, stops government from interfering with such relationships, but there can be restrictions to this right. As stated, under are there any restrictions to this right? There are situations when public authorities can interfere with your right to respect for private and family life, home and correspondence. This is also allowed where the authority can show that its action is lawful, necessary and proportionate in order to protect national security, protect public safety, the economy, health or morals, disorder or crime, or protect the rights and freedoms of other people. Action is proportionate when it is appropriate and no more than necessary to address the problem. So bearing in mind, they can just restrict the rights if there is, if action is needed. So, and bearing in mind, they're not very articulate on which part of the right to family life is in fact a problem for national security or what have you. So this is very concerning. So for number 4, they want to reduce the burdens on public authorities. We are limiting the imposition of positive obligations on our public services without proper democratic oversight. We are making clear that when public authorities are giving clear effect to primary legislation, they are not acting unlawfully. We are doing this by restricting UK courts' power to interrupt legislation. This will deliver greater certainty for public services to do the jobs entrusted to them, without the constant threat of having to defend against expensive human rights claims. that in itself is just bizarre. So by reducing the burdens of public authority, they want to cut the courts out when the police, the chief of police or the minister of security are writing up new legislation, which I don't know why, evicting the courts out of this process is bizarre. The very embodiment of the law should be in direct hand with the police when writing down legislation. And yeah, if you put it into law, they're technically not acting unlawfully because it is the new legal system. Just fucking weird wordplay. And not only that, they want to defend the police against expensive human rights claims. And by that they mean this one. So the largest human rights claim cost the UK government £60 million. The 29th of March 2008, the government/administration human rights, a total of almost £60 million have been paid out by the UK government in what is believed to be the highest ever compensation for a claim under the Human Rights Act of 1998. So these new bills want to restrict people's rights on being able to call out the fact that their rights have been infringed upon. And not only that, giving more power to the police and defending them in case they do violate somebody's human rights or group or communities or groups of human rights. Yeah, that's number 4. So number 5, ensure the public protection is given due regard in interpretation of rights. The bill contains a provision that obliges all those who interpret convention rights to consider the need to reduce the risk to the public from convicted criminals serving a custodial sentence. This supports the government's proposed reforms to the parole board and strengthens the government's hand in fighting Article 8 claims from terrorists opposing their placement in separation centres. Yeah, okay. Again, still makes no sense. Yeah, still trying to fight hard to get rid of Article 8 claims from terrorists opposing their placement in separation centres. But yeah, as you can clearly see in Article 8, the restriction is opposed. You can restrict the Article 8 right to protect national security, public safety, disorder or crime, health, morals, economy and all that. And all of that. But yeah, if they're terrorists, that obviously means they are at risk to public safety, national security, health and morals. It'll help prevent disorder and crime and protect the rights of other people. So I don't see how getting rid of this Article 8 will somehow improve to put terrorists into separation centres. If they are convicted terrorists, then the article clearly states that it's fine. So this is just ridiculous. Number 6, though, limits the bill's territorial jurisdiction. Domestic and Strasbourg case law has extended beyond the intent of the convention's drafters. The bill excludes extraditional jurisdiction for military operations abroad. I am not too sure what that means. Believe it's... I don't know. I don't know. So I will not comment on number 6. 7. Implemented permission stage to ensure trivial cases do not undermine public confidence in human rights. Permission stage to ensure trivial cases do not undermine public confidence in human rights. If your human rights being violated, it's not trivial. So I'm not quite sure what they mean by trivial, because if your human rights haven't been impeded upon, then it can't go to court because no crime has happened. Now, this one is also kind of worrying. The introduction of a permission stage will ensure that courts focus on serious human rights claims and place a responsibility on the claimant to demonstrate that they have suffered a significant disadvantage before human rights claims can be heard. Because bearing in mind, most human rights violators are governments, conglomerates, and people of high power. And since your human rights have been have dismissed, right? Lack of a better word. How are you supposed to get all the evidence to have the court to even take you seriously? Which is just bizarre. Like, I don't even understand. Because bearing in mind, most of these people are asylum seekers, refugees, and immigrants, the people with the least amount of powers. So I don't understand how they're supposed. So not only do they have their human rights violated, but then also somehow have all the significant paperwork, somehow educate themselves as well on British human rights courts actually work, and the money, because you need the money. You can't just go to court and ask them to pay for it. No, you have to pay for it. At least a lawyer, sorry, to look at it, because it has to be presented in a certain way, and then somehow go to the court and just somehow prove to them that your human rights have been violated. It's ridiculous. Like how in God's name are you supposed to achieve such a thing? Yeah, to me it just seems another way on. Yeah, I just don't understand it. Number 8, recognize the responsibilities exist alongside rights. We are recognizing that responsibilities exist alongside rights and ensuring that the appropriateness of paying damages to those who have been infringed the rights of others is considered. Yeah, so just compensation. If somebody's human rights have been violated, the government accepts the fact that they should compensate such a person because their human rights are violated. That's already in there, so I don't see why that has to be a thing. Number 9, strengthen domestic institutions and the primacy of UK law. The bill empowers UK courts to apply human rights in a UK context, affirming the Supreme Court's independence from Strasbourg Court. The bill makes explicit that the UK Supreme Court is the ultimate judicial arbiter. So yeah, in other words, trying to separate the British courts from the Strasbourg Human Rights Court, and make sure that the UK is the sole decider of what happens in the courts, and what it says goes, which is just ridiculous. Because bearing in mind they're trying to restrict rights to somehow improve security and safety, which makes no sense. This is just power grabbing, and quite frankly, it will have serious consequences in the future. Because obviously the British courts will always side with their best interests, as they have been for a long time. Number 10, increase democratic oversight. The bill makes sure that the balance between our domestic institution is right by repealing Section 3 of the Human Rights Act of 1998 to ensure that the UK courts can no longer alter legislation contrary to its ordinary meaning and overall purpose of the law concerned. Section 3 of the Human Rights Act of 1998, HRA, reads as follows, right? So far as it is possible to do so, primary and subordinate legislation must be read and given an effect in its... I don't have a fucking clue. I don't know. I know. So I'm not sure what this is supposed to do. Enhances parliamentary role in responding to adverse Strasbourg rulings. The bill enhances the role of Parliament in responding to adverse Strasbourg judgment against UK. The bill also affects every time the United Kingdom Parliament new laws or legislations, and Strasbourg the Parliament does not have to change those laws. In fact, they can that would go against human rights. 11, as well as number, I find very concerning, more so as whatever laws without